Constitution of the Republic of Singapore Amendment Bill. Item 2, Adoption of Children Bill, second reading.
Minister for Social and Family Development.
First and foremost, our starting point is that every child deserves to grow up in a loving family and a caring community. We want our children to thrive under the care of trusted adults. This is part of our social compact in Singapore, where families form the bedrock of our society. They are our first line of support. The government will preserve strong families because they are our foundation that nurture and build resilient individuals, together with the support of caring community. However, we note that in some instances, a child's birth parents may be either unable or unwilling to care for him or her. This is when the government must facilitate alternative and needed care arrangements. Where reunification with their birth parents is unlikely, adoption into a strong and stable family is an important enabler, providing the children with a better chance of having a good start in life and achieving better outcomes. Today, adoption in Singapore is governed by the Adoption of Children Act 1939, or the ACA. The ACA was last substantively amended in 1985. Since then, the adoption landscape has evolved significantly and seen several key developments. First, adoption applications have become increasingly complex. MSF is seeing more adoption applications involving children with high needs and prospective adopters with concerning issues. Second, some vulnerable children in state care who would benefit from adoption face obstacles in the adoption process, primarily due to objections from their birth parents. And third, commercial adoption against the CAAs have become more prominent in the adoption sector. With a limited number of local children available for adoption, prospective adopters have sought their services to source for foreign children. Over time, MSF has received feedback about such CAAs engaging in undesirable practices that are financially motivated, with little or no regard for the interests of the child, prospective adopters, and birth parents. While MSF has administratively addressed such undesirable practices, legislative levers are needed for greater deterrence because this cannot be tolerated in our society. Therefore, this bill will repeal and reenact the ACA with enhanced provisions to govern the adoption sector, practices and processes in Singapore, and to better safeguard the child's welfare. First, finding a good home for every child. The first trust is finding a good home for every child identified for adoption. As I said earlier, the key focus of adoption is the child's welfare, rather than about supporting parenthood. This means ensuring they are adopted by families who can provide good home environments for them. Second, we will provide more guidance on who can adopt jointly, given the differing marriage laws across jurisdictions. The bill specifies that applicants married under Singapore law can do so. For couples who married overseas, only those who would be regarded as lawfully married if their marriage had taken place in Singapore can adopt jointly. This means that only a man and a woman married to each other can apply together. This is because Singapore's marriage law only allows a man and a woman to marry each other. The government has also stated that it is a matter of public policy that we do not support the formation of same-sex family units, which the High Court has affirmed in December 2018 in UKM and Attorney-General. We reiterated in January 2019 that we do not support the formation of same-sex families through processes such as adoption. These public policies will be taken into consideration when determining suitability to adopt. Under Clause 60, it will be an offense for key parties involved in adoption proceedings in the adoption sector to fail to report suspected offenses under the bill to the GIA or an officer authorized by the GIA. Under Clause 72, individuals who report, whether voluntarily or under a legal obligation, will be protected from legal liability for reporting. The identity will also be protected during court proceedings. In addition, under Clause 73, key parties performing statutory functions, such as the GIA and staff in authorized adoption agencies, will be protected from personal liability if they have acted in good faith and with reasonable care. As the majority of applications in Singapore involve inter-country adoptions, the proposed offences will have extraterritorial effect under Clause 50. This means that if an offence is committed by a person outside Singapore, the person may be dealt with as if the offence was committed within Singapore. The penalties for first-time offenders of an offence in the bill range from a fine of up to $5,000 or $10,000 and/or imprisonment for a term up to 12 months or 3 years. The penalties are higher for repeat offenders and offences targeted at commercial adoption agencies. To enforce these new offences, Clause 61 to 63 provide the GIA and authorized officers with powers of enforcement, while Clause 64 and 65 clarify that it would be an offence to obstruct enforcement or provide false or misleading information to officers performing enforcement functions, such as an officer authorized by the GIA.